All right. Welcome everybody to Family Law Now. And our amazing presenters are joining us. Bill Rogers, Daniela, welcome. How's everybody doing today?
I'm doing well.
So, yeah.
Excited
Doing good,
for
Bob.
the discussion.
Did you get, you still have the sun there, Daniela?
Yeah, it's still sunny right now. Hope it lasts, but I think it's supposed to rain this afternoon.
Yeah. And our host with the most, Shannon, welcome.
Hey,
Great to see you
everyone.
again.
Thank you. Nice to see everyone too. Looks like we have a great turnout today. Looking forward
Yeah.
to the presentation and hearing your insights.
Really good numbers. Might be one of the records for 2024.
Yeah, popular topic.
I was saying to Danielle earlier today, Bill, you guys have created a bit of a buzz. I did a CP meeting this morning. Harrison, the lawyer, and Jonathan and Carrie, the family and financial professionals, are all signing on to cheer you on. Hopefully it's not a car wreck. We'll see how it goes.
Yeah,
How was
right.
how was the axe throwing event?
I think that's tonight or
Oh, it's
tomorrow.
tonight. Okay. I wasn't
Yeah.
able to I'm not able to make it, but I've always wanted to try that.
I'm
Axe.
always worried I'm going to get an axe in the back of the head by somebody who doesn't like me. So
I'd wear a helmet.
the last one I was at, there was an open bar. And you could bring your own cooler.
You know, combining alcohol with axe throwing.
Not a good idea.
Sound like the best idea, does it?
Yeah. We actually did an axe throwing event for the firm pre-pandemic.
Was it Carrie's idea? Because I'm a little concerned.
Have you done it?
Nothing worse than a violent financial professional.
Shannon, have you done axe throwing?
I have. I went for the first time earlier this year. I was a little intimidated by it beforehand. Also a little concerned about, the drinking, the axe throwing. But I made it out alive and I was better than I thought I would be.
Let's hear from our audience. Put in the chat if you've been axe throwing and where you went and what your experience was. When I went, they had a round robin, but they finished it off with this big axe. Did they have a big axe at yours? You got to throw the big axe?
Yeah, one of the people that worked there brought it out at the end to try, and I was like, I could barely lift it. I was like, I'll stick with the regular size axes. I'm not at that level yet. But she was talking about how they she's like part of these competitions, like there's these leagues that you can get into, and
Oh yeah.
I was intrigued by the idea.
Yeah. Have you tried it, Daniela?
No, I haven't. But I'm wondering, is it the same feeling of like the release of like boxing or something would be? Like you can kind of get your stress out, or is it just
Pretty satisfying when the axe actually sticks to the wall.
we get it there?
You can tell the people who are in a league because they've got this, they can kind of hold it backwards and they kind of shoot it like a gun from their hip. I'm thinking, oh my God,
Oh, wow.
you've been doing this way too much. But fun times.
But
I'm
it's
not
also,
saying-
there's like a certain art to it too, where I thought, like you said, Daniela, that it would just be getting your rage out and just throwing as hard as you can. But like there's also kind of have to have this balance of throwing it hard enough, but not too hard.
Okay.
You wanted to try to spin so many times, right?
Wow.
Yeah.
I guess it's sort of like golf. You try to hit the golf ball too hard, you're going to dump it, right?
Yeah, that was my issue with golf.
Have you ever tried golfing with an axe?
Ooh,
There you go,
yet.
Bill.
Not yet, Bill. Next team event.
Bill, let me know what course you're going to so I can avoid that neighborhood.
Okay, well, I think that's enough about axe throwing for today. We better get into the content. So just want to officially welcome everyone. Thank you so much for being here. If we haven't met before, my name is Shannon, and we have the lovely Daniela, Bill, and Russell, who will be presenting today on mastering trial prep, key tactics for family law success. So I'm just going to quickly give a brief background on our speakers and then also let you know what you can expect over the next hour, and then I'll hand things over to our panelists. So first I'm going to introduce Daniela, who is an associate family lawyer at our firm, where she takes pride in guiding clients through separation and divorce process by listening to their struggles, worries, and needs, and advises them on their legal rights, entitlements, and obligations. Daniela has been practicing family law exclusively since 2007, and prior to joining our firm, she ran her own practice. Daniela always advocates passionately on her clients' behalf to ensure that their objectives are met. She is a firm negotiator, trained mediator, collaborative lawyer, and experienced litigator. Next, we have Bill Rogers, and Bill is a managing associate lawyer at our firm. His courtroom experience includes numerous motions, several full-blown trials, and he has also had the privilege of winning a major family law victory at the Ontario Court of Appeal in 2014, McConnell versus Huxtable, which prevented the imposition of a proposed 2-year deadline on property claims by common law spouses. And last but not least, if this is the first time joining our virtual event series, we have our founder, Russell Alexander. He's the founder at our firm, and with over 25 years of experience, he uses his knowledge and expertise to service clients in all aspects of family law and helps them cope with the difficulties of separation and divorce and other family law matters. Russell has written 4 books on separation and divorce and is a fully trained collaborative practice lawyer. He speaks at conferences on collaborative practice, marketing, technology, and the law. And what you can expect to hear from our speakers over the next hour. We have start at the end, crafting your final proposed order, timing and the balance between trial prep and settlement negotiations, preparing for trial. We also have witness preparation, conducting the trial, the decision, cost submissions, and lastly, our panelists will be discussing imposter syndrome, the anxiety that might come with trials, what you can expect, and their tips and tricks. And as always, we encourage our audience members to send in any questions you have on this topic, and our speakers will do their best to answer throughout the presentation, as well as we'll leave some time at the end for a dedicated Q&A segment. So the chat has been disabled. However, you can send those in through the Q&A button that's just at the bottom of your screen. And so on that note, Russ, I'll let you take it away from here.
Yeah, a couple things before you run, Shannon. Let's throw our poll up. First poll. Have you ever conducted a trial? And we'll give everybody a few minutes. If you've been axe throwing, put the, what are we using here? Not the Q&A, right? Not the chat.
Right.
Put your answer in the chat. Let us know where you went. And Shannon, can we offer our guarantee today? What do you think? We haven't done it in a long time.
The money back guarantee.
How's that work?
You're gonna make me say it, Russ?
Sure.
Well, I would say we always like to, but this is like an old school joke that Russ used to say at the beginning of our series, so that we always offer our money back guarantee for our free virtual event. So here it is today,
Yeah.
and we'll stick to it. But we hope that everyone's happy with the webinar.
And what we really enjoy is audience feedback. So please put your questions in, participate in the polls. It helps us tailor our content to our audience. Shannon's going to likely include some show notes and a questionnaire at the end. You can also give us your feedback then in terms of topics that you want us to present on, how we could improve. If you'd like to be a presenter and you have an idea, send in your information and we'll try to get you on our panel. So, have you ever conducted a trial? Let's see what our poll results say. Need a drum roll. Yes, 47%. No, 40%. Preferred trials outside counsel, participated in certain aspects. So a little bit more than half have participated. That's a lot higher than I was expecting, because I know a majority of the family law lawyers in my community do not do trials. Their cases settle and or they hand them off. So what would you, those polls results, Bill, is that what you expected?
Yeah, I'm surprised so many people have. I mean, and I can't call myself a master of a trial. I mean, I've done 5. I know someone who did 30.
Yeah. Daniela, thoughts on the results?
Yeah, I'm surprised too, because, I think the whole time I've been practicing family law, I always hear the same statistic about, 97% of cases settle and they don't go to trial. So this is a surprising result, in my opinion.
Yeah. And we've got our audience's questions coming in. Thank you. We're going to get to questions during the polls, and we're going to save some time at the end for Q&A. We do have an axe thrower who did it in Philly, but there was no alcohol. So it was an amazing event. So thanks for sharing. Okay, let's make a start. Start at the crafting your final order. What do we want to think about here, Danielle?
Okay, so I guess what I would recommend is to go back to your client's pleadings and make sure you deal with each of the outstanding issues in the pleadings that's going to be dealt with at the trial. And also, because really, like, a judge cannot make an order for the relief that's not in your pleading. So if you have to amend the pleading, you deal with that usually at the trial scheduling conference. So you want to make sure that you capture all of that in your draft order. And then also, like, reserve an opportunity to provide the judge with a refined version of your draft order when you do your closing submissions. So those are my tips for a draft order.
Yeah. Bill, thoughts about starting at the end?
Yeah, I think Danielle is right. I mean, although didn't we get some stuff in our trial that wasn't in the pleadings? Like, judges can order stuff that's not in they can. But Danielle is right. You're better, you try to follow your pleadings.
Yeah. I like starting with the final order and then working backwards. What evidence do I need to establish this property claim? What evidence do I need to support this parenting claim? And then work backwards. What can I point the judge to in terms of the documents and the witnesses to support the particular positions I'm taking in the order? Because that's how I'm going to wrap up the trial. I'm going to say, here's my draft order, and this is why we need you to make this order, and then refer to the evidence. But timing and balance between trial prep and settlement negotiations.
Yeah, I would say it's safe to say that about a month leading up to the trial, most of your work days are going to be consumed with trial prep. You would likely have to start ignoring your other files for this period of time. It's a good idea to put an auto reply on your email to say that you're going to be slower to respond and that you're preparing for trial. And then during the time that you're focusing on the trial prep, you're also going to have to balance that with trying to perhaps resolve or settle some of the issues with the opposing counsel or the opposing party if they're self-represented. So you have to really give yourself time in your day to kind of, because, leading up to our trial, I know I was going back and forth with opposing counsel on certain issues. But you really have to keep your focus on the prep because, likely you may not settle. So you have to try to really focus on the prep too and divide your day. I think your work day will be consumed with this particular file, no matter how you look at it. That's my 2 cents.
Oh, sorry, Bill, your thoughts?
Danielle is right. And a lot of time the trial will settle on the first day of trial too. So I did a trial in front of Justice Harbison Young, or I should say I didn't do a trial, because when the trial started, the trial was actually going, just started, and she said, they've done studies. Most people feel worse after a trial than before. So do you guys want to settle? And we did.
Yeah. When I saw this topic, my thought was trial prep is so intensive and so expensive, right? The documents, the witnesses. The balance that I'm seeing is, okay, At what point do I view that a pre-trial settlement is not going to happen? Somebody's taking a position that's unreasonable. And because I know at that point, we're going to be into it for $15,000, $20,000, $30,000 in legal fees to get ready. So that's the tipping point. When I feel that, we've hit a bit of a wall, we're not going to get anywhere, maybe until an exit pre-trial. That's when we'll render an offer based on that issue that I think we can beat. And so if they force that issue onto trial, and we'll build in a cushion, maybe $5,000, $10,000 in the offer, knowing that's going to be flushed down the toilet in trial prep. And at that point, when we go into trial prep, that issue is done for us. We've got our offer. If they try to negotiate last minute, we'll probably run it through a trial because we know we're going to beat our offer. But you don't want to be too overconfident on that as well. All right,
here's
so
something to not say to opposing counsel if it's going to trial. Do not say, "I'll see you in hell." And I know this from experience.
Is that what they said to you, or you said it?
No, that's what I said.
Oh, Bill, come on. You've got the rules of professional conduct. All right, let's get our next poll up. On average, how much preparation is necessary to do 1 hour trial? And while we're doing this, we're going to go to some audience questions. We're getting some great questions coming in. Thank you. Keep them coming. One question, a couple questions from this one audience member. Who are good witnesses for trial? I like third-party professionals that don't have a dog in the fight. They're usually the most credible. That could be sometimes a child protection worker, some kind of business valuator, or not business valuator, but somebody unrelated to the parties in the litigation. We're not paying them for a report. What do you think, Daniela?
The best witnesses?
Yeah. Or who are good witnesses for trial?
Well, I think someone who comes across as genuine and authentic, and they're really speaking honestly, and it's clear that they're being forthcoming and authentic in their approach. I think that helps. Someone who's obviously prepared, but not looking too scripted, I would say. Yeah.
They have to have relevant evidence too, right? We don't want the Greek chorus coming in just to cheer on your side of the case. That's not going to help the trial judge. Your thoughts, Bill?
When it comes to witnesses, I agree with what you've said, and I would also add, generally, less is more. If you have 3 witnesses, they're going to say more or less the same thing. Pick one.
Next question, same audience member. What evidence is best to prove your position, not upsetting the judge? I think documentary evidence is pretty powerful. It's hard to cross-examine or refute a bank statement saying this was a balance on a certain day, unless the document's a fake. But I think documentary evidence, the court likes that. They'll rely on that pretty much every day of the week. Your thoughts, Bill?
Yeah, certainly when it's a financial issue. Trial Daniela and I did recently was parenting, so it was very much viva voce evidence.
Yeah, and medical.
Daniela, thoughts?
Yeah, I think that you don't want to also include organized documents, but I guess we can go into this when we talk about the document and exhibit briefs. But you don't want like 2 years worth of Rogers bills if they're not relevant, right? You want something that's, concise enough but important for your particular for the point or the evidence that you're trying to prove. You don't want it to be so voluminous that the judge is going to be annoyed to have to go through all of it.
Yeah, that would probably upset your trial judge.
Yeah.
So let's see what our audience is thinking. Trial prep for 1 hour trial. Well, nobody's winging it, so that's a good sign. 1 hour prep for 1 hour trial, 8%, 3 hours, 51%, more than 3, 36 other. Please put it in the Q&A box. That feels about right. I'd say 3 to 1 would be my guess. What do you guys think?
Well, during the trial, our trial was a week. Remember, Daniela?
Yeah.
And during the trial, you have to work around the clock because things keep changing. Stuff happens. The judge will say something and you'll go, oh my God, I've got to address that. And so you really do have to work while the trial is going on. You have to go to sleep, obviously, but if you're not asleep, you're working into the night.
Yeah. The analogy I like to draw is sort of like it's a classic Harley Davidson, right? For every 1 hour of riding, you're doing 3 hours of repair. So that's sort of the back end going into a trial. You're gonna have to prep, and it depends on what state. If you're doing an examination in chief, that might be less time than doing cross examination, where you're going to need to have the documents ready to impeach the witness if they're not cooperating, or you're not going to have to read the discoveries or the questioning and have 3 days of transcripts memorized for the witness when you're confronting him or her.
As Martha McCarthy famously said, the way you win a trial is to out-prepare the other side.
Good tip. So trial management conferences. Let's talk about actually preparing for the trial. That's a good lead, Bill. Trial management conferences is kind of a unique opportunity for the clients and counsel.
You want me to talk about the trial management conference?
If you can, sure.
Yeah, sure, of course. If in doubt about including a witness on your witness list, include the witness. It doesn't mean you have to call them. Whereas if you don't include a witness and you try to add them later, it can be a problem. If you try to add a witness during the trial that's not on the list, you can, but you have to there has to be a reason for it because they don't like surprises. So you'd be like, well, I didn't know this person would have this information. I just found out. That's fine. But, if in doubt, put the witness on the list. And then when you actually do the trial, I would say less is more. Again, if you have 3 people who are going to say more or less the same thing, I prefer to choose one. Not everyone does it my way. I have my way of doing it. There's lots of different ways, but that's what I do.
Yeah, I agree. Estimating time for trial. This is a science too, right, Bill?
Be generous because it takes sometimes it takes a long time to do stuff in a trial. It's actually a trial is the most fun and it's easier than a case conference or a motion, actually. But it can be slow. So err on the side of estimating too much time. In my experience, such as it is, if you run out of time the judge can tell on day 2 whether it's going to take too long, and they will add days to it.
Be practical though. You're probably only getting 4 or 5 hours of trial time in. Start up at 9:30
per day, you mean?
Yeah,
Yeah, absolutely. Yeah.
You take a break. There'll be mid-morning break, mid-afternoon break. Judges tend to like to wrap things up by 4:30. They may go to 5 if a witness is in the middle of his or her testimony.
Yeah.
So there's not a lot of actual sitting trial time. And it can go sideways quickly, right? You may be asked to do a mid-trial pre-trial. That could take half a day. I was in Newmarket. I estimated 3 days for the trial. Day 2, there's a fire in the prisoner cells and they have to evacuate the building. So there's 400 or 500 people. We're all in the parking lot. We have our robes on. They get the fire out. Now they got to get 400 people back into the building through security. So day 2 is pretty much a write-off. We had maybe an hour of trial time. How could you estimate that? So now it's a 4-day trial. You're still getting paid to stand in the parking lot, but you can't predict what's going to happen when you go. But how you agree with that, Danielle, in terms of estimating trial time?
Yeah, like I remember we had 5 days of trial, but then there was the availability of certain witnesses. Some of them we did on Zoom, but there was talk of if we went over the 5 days that we would have had to then continue on, but the judge wasn't available until 2.5 months later. So there would have been this gap of time and it would have kind of dragged out, but thankfully we were able to get in the 5 days. So it's very important to, like Bill said, to overshoot. And then if you finish early, great, but you don't want to be in a situation where you started the trial, you've gone through 5 days of it, but then you have to continue on, and it's not till 2 months later, because that could be really, really stressful for your client and for yourself, because you're just intending to get this done and prepared and over with. So that's, you got to be, you have to roll with it. But yeah, I would say overshoot is much better than not having enough time.
Getting some great insight from our audience. If you have a witness on the trial scheduling endorsement form and don't call them, my understanding is that they must be made available to the case where the other side still wishes to examine them. That's my understanding too. So if
Oh,
you're
really?
listing,
I didn't know that.
if you're listing a witness, you got that witness, the other side can call the witness whether or not.
Well, yeah, but they wouldn't, they'd be calling them in chief. It would be weird.
Yeah, they could still call the evidence. So
I guess, yeah. I've
you can
never,
have them declared a
yeah.
hostile witness too. Another question that came in: how do you convince a judge that they are not permitting enough time for trial? Good question. You guys want to take a crack at that? I got an idea what to do, but
Never say anything like that to a judge. You say, yes, Your Honor. And then if you need more time, they add a day. And usually they add days like in the following week or two.
depending on the schedule, yeah.
Yes, Your Honor.
The judge
Yes,
can't
you are
rush you
correct.
through. They can't rush you through your case. Your client has the right to be heard. Call the witnesses that are properly available. So they can't say the trial is over, you're out of time.
And opposing counsel can speak in slow motion. Your Honor, I say to you. And that took about hours and hours. And anyway, I still have nightmares.
Okay, let's move on to offers to settle. Daniela?
Okay, so offers to settle should be made in every case. It's so important. For trial, more than 7 days before trial, you should, I would recommend that you do it well in advance of trial, but it should be made more than 7 days before trial. So if you're kind of going back and forth with the opposing counsel, you want to do another offer to settle, make sure it's done more than 7 days before trial. Make sure the terms are quantifiable or measurable so that they can be used for comparison to the results at trial. Make sure you capture all the issues for trial in your offer to settle, like I discussed earlier about looking at the pleadings and, making sure that your final order, your draft order, and your offer to settle have the similar issues or the same issues. Make sure the terms are within the jurisdiction of the court to order, and clearly state whether they're severable or non-severable. Make sure your client and the lawyer both sign the offer to settle, that it's made in writing. All of the, Rule 18 and Rule 24, those are important to review and consider before you're making the offer to settle for trial.
Bill, thoughts?
And yeah, I agree 100%. Yeah.
You can have escalating cost consequences too, right? Open for acceptance without costs and partial indemnity up to a certain date on specific issues to hopefully trigger the other side to accept. You can make them. You can make parts of your offers severable, right? You can accept the parenting issues and we'll litigate the support issues. And if you win on that particular issue, then you should be able to recover for some costs. So
usually remains open until, 1 minute after the commencement of trial.
I
wonder if anyone's ever accepted it like within that minute.
If you want to engage the rule, I did see
it's
a lawyer,
15 seconds in, and I'm accepting.
I did see a lawyer. It was going to a jury trial. It was a civil case. And he accepted the offer from the insurance company just before the judge walked into the room. And the insurance company lawyer said it's not open for acceptance anymore. And he said, the trial hasn't started yet. I'm accepting the trial in the courtroom prior to the judge walking in. So you can cut it pretty close to the line, but that was an exception. They were playing poker, right? Who's gonna give in first? And that was what happened in that one. I forgot to mention at the beginning, we're talking all about trials today, but there's another alternative. You can settle your cases outside of the court system using collaborative practice. That's sort of the bookends of resolving disputes. A lot of people are interested in the trial work today. We do have collaborative practice training. Shannon will put a link into the chat if you want to learn more about it. It's starting up in the next couple of weeks, and there's a discount code. We'll have more information at the end. But let's talk about trial retainers. You want to be properly retained before agreeing to do a trial. It's going to be difficult for you to get off the record once it's set. You've had your trial management conference. Criminal cases and child protection cases, it may be nearly impossible for you to get off the record. I see lots of counsel file Form 4s and fire their clients on the eve of a trial because they're not properly retained, which is sad because they're leaving their clients on a bit of a lurch. So as a general rule of thumb, we would ask for $5,000 a day. For a 5-day trial, it's $25,000 retainer, probably a $20,000 or $25,000 retainer to prepare for that trial. And then if during the trial, if it looks like it's going to go longer, I'll tell the client, we'll give the client interim bills every other day. They'll get an account saying, here's how much time you're into it for. And if it's looking like it's going to run late, when we're on day 3 of a 5-day trial, the client's going to have to top up their retainer by 10 or 20 grand. Last thing you want to do is be worrying about and focusing on getting paid. You want to focus on your arguments and providing the best advocacy for your client when it gets to that stage. But that's my approach. Danielle, Bill, what do you think?
Yeah, I would say like it's so much work. You want to make sure you're getting paid. You want to make sure that you have an adequate retainer. Because as Bill said earlier too, is like every day of trial, not only are you in court all day, but then you're still working in the evening to prepare for the next day because it's constantly, it's fluid, it's moving. You have to deal with what was said in court that day, formulate some cross-examination questions for the next day. You got to be on the ball. So it is quite a time commitment. So you need to make sure that you adequately request the proper amount of retainer.
Bill, thoughts?
Yeah, I agree. And I was in Milton last week in Superior Court for the first case conference. So the judge gave the talk to the parties and said, you know what, you don't want to go to trial. So I hope you can settle this eventually because this would take a 2-week trial, your case, and a 2-week trial costs $500,000.
Yeah, probably for both sides. And
I'm like, I want to find these clients who are paying $500,000 and sign them up.
they pay them. Read the Ontario reports. Some clients are getting $1 million cost awards. That's just the cost of doing trials. So directions. Again, we're still talking about preparing for trial. The directions are designed to cover your ass, right? With a law society complaint or a claim with Law Pro. Somebody's going to be upset at the end of the trial. Oftentimes, clients will turn on their counsel if they don't like the result. So for directions, I will get directions regarding offers to settle. If the client's asking me to make an offer that is inconsistent with my advice, I'll say I've recommended this amount. You're telling me to do this. You're signing a direction off on it. I will include case law in the direction and say this is what the court's been deciding on this particular issue. I will include their instructions. You've specifically instructed me to do X, Y, and Z. I will include my advice saying, this is what I think you should be doing. And I will mention the risk. There's no guarantees. We don't know who we're going to pull as our trial judge. Our evidence may come out badly. Their case may be great. It could be the other way around. Trials are inherently risky endeavors. The judge may not see the case the way I see it, or they may completely agree. We can't predict what the outcome is going to be. So all those are included. I have them sign it off well in advance and let them think about it. Clients are entitled to make a bad argument, right? We'll run a case and we don't think they're going to be successful. They're still entitled to have their day in court. But paper your file. So if there's a law pro claim or complaint with the Law Society, you can say, this was my instructions. The client signed a direction. We fully of using directions prior to trial?
I would agree because there's, clients are very emotional. They're also spending a lot of money. So you want to make sure that it's clear in writing what they're instructing you to do, how they're instructing you to proceed. It's important.
Bill, thoughts on directions?
I agree with everything you said. And one of my bosses, who shall remain nameless, gave me a client and said, Bill, and it went to trial. And I was told that the client, quote, he's a nut bar and he dug his own grave.
That wasn't me, was it, Bill?
Maybe.
Let's see what our audience is thinking. Have you filed your documents when how have you filed your documents? Okay, yes, we're moving in to document preparation. So let's find out, you've been filing in paper, electronic, hybrid, are you using case center or what they call case lines? Walk it in, that's Bill's favorite way to do it. Just found the document in the back of his car. He wants to get it before the judge. Let's see what our audience is thinking. Let's see if we've got some Q&A. Well, this is a good one. How do you declare a witness hostile? Does the process take significant time, and how do you impeach a witness? Well, there's a formal process to impeach a witness, right, Bill? We're going to get to that.
I've never had that happen. Declaring a witness hostile means it's your witness, and they're not saying what they're lying or whatever. So then you can cross-examine them, even though it's your own witness. I've never had it happen, but I'd like to see it happen.
Well, I suppose if you called one of the other parties witness off their trial scheduling form and was required to examine them in chief, and they were being evasive, but
that's a good point.
And impeaching a witness with a document or prior testimony, there's a specific procedure set out. You want to establish that it was under oath and present them with an opportunity to review it. Certainly, you want to make sure you follow the right steps. But let's see what our audience is thinking in terms of this poll question. How are people getting their documents into the court? Paper with extra copies. So it was pre-pandemic, that was always the way, almost always. We'd have 5 copies for everybody, right? You had the witness, opposing counsel, the judge, yourself, your client, there may be a court copy with the registrar. 30 hybrid, 38% paper electronic, case center, 39%. So yeah, it's really starting to take over.
Is it case lines or case center?
Well, I think it's case lines, but didn't they just update their name recently?
Yeah,
They've got a program. And then walk it in, Bill. You're the only one walking in documents, and now they put it in the
well, and the way they do it now with case lines or case whatever the heck it is, you have to bring a computer and screen screen mirror, like you project your computer onto the screen and then you go into case lines. So it's not that easy to do. You need an assistant to do that.
Okay. Got lots of questions coming in about cross-examination and preparing witnesses. Hang on, we're getting to that. Document preparation, trial record. This is a pretty important document, right, Daniela?
Yeah, so usually it's at least 30 days before the start of the trial. The applicant usually serves and files the trial record, and there's a specific rule of what it must contain. I think it's rule 23. The application, the answer, the reply, any agreed statement of facts, if relevant to the trial, an updated financial statement for both parties, net family property statements that are completed relatively, like recently, like within 30 days of the trial record being served. So those have to be up to date. If the trial relates to decision-making or parenting time, you have to include the 35.1, an updated one as well. Any assessments or reports ordered by the court or obtained on consent. Any temporary orders relating to a matter that's still in dispute. Any order relating to the trial. And any relevant parts of transcripts on which a party tends to rely on. So if there's been questioning, you would include the questioning transcripts as well.
Yeah. And it said in the rule exactly what documents you got to include in the trial record. Just follow the rules and tick them off as you put them in. Expert reports too, right?
And they changed the
Okay.
rules a few years ago. Expert reports are now due before the settlement conference.
They still go in the trial record though.
They do, but it
Yeah.
used to be much later.
Financial statements go in the trial record. You want to make sure and spend a lot of time making sure your financial statement for your client is up to date and accurate. This is great fodder for cross-examination. Usually in the trial record, you may have 4 or 5 financial statements if it's been litigated for a few years. And it's very easy to see the inconsistencies within their own sworn financial statements. And if they're saying, you know, transportation's $500 in year 1, and then all of a sudden they're claiming $3,000 in transportation costs. Lots of great details you can get at in cross-examination in terms of what's changed, how they're financing it. Same with the income and tax information. Lots of really important information. You want to make sure your client's financial statement is up to date and accurate. You're going to want to review these with the client. If there's inconsistencies, you're going to want to get an explanation as to why the numbers are changing. Try to get supporting documentation. If it's a bank record or an entry like that or an investment account, include that in your document brief so when the witness or your client is cross-examined, they can reference the actual source document to explain how they got the numbers. NFP comparison statements, super powerful tool. Judges love these. They're not evidence. You can hand it in. It's a form of roadmap, in my opinion. Very quickly, you're going to find the 9 or 10 items that are causing the equalization payment to deviate. That allows the court to focus its attention on these specific areas. And then you drill down. Where are the documents? Where's the evidence to support these changing numbers? It narrows the trial significantly. If the judge was just looking at the financial statements, he or she is going to have to understand why the number is different. If you have an NFP comparison statement, you can highlight the columns where the numbers are off. And then you start telling your client's story in terms of why your particular numbers are the correct ones to go with. And muster the necessary evidence to support your client's case. Exhibits and document briefs, also very important. Daniela?
Sorry, I was on mute there. Yes, so you have to make sure you comply with the term set out in this trial scheduling endorsement form, the deadlines of when to serve certain documents. Some trials include affidavits for direct evidence, and then you have like some time allotted in trial to kind of present that evidence in a more summary way, and then you do the cross-examination. So you have to kind of get the lay of the land of what documents you're going to be including. You have to put together the book of the proposed exhibits. So they're what you intend to rely on in court, but they are not yet evidence for trial. So that's an important distinction as well. You want to meet in advance or discuss with the opposing side to address or at least flag or resolve, any evidentiary evidence in the affidavits or the proposed exhibits that will potentially be an issue in trial. You might want to do a really comprehensive statement of agreed facts that can help the judge if you have a good working relationship with the opposing counsel. And then you want to also focus on the balance of your evidence and the facts and how they align with the legal tests. You want to submit your statements of law and annotated case briefs that have to be hyperlinked at the start of trial. You want to ensure that you complete a bill of costs and a compilation of your offers to settle in a chart. So that way, at the end of trial, you have that if a judge, asks for for the discussion with respect to costs. I think that's pretty much covers most of it.
Yeah. And we're going to get into filing in a moment. Just a couple other things about preparation though. Expert reports, in the Evidence Act, you want to follow the rules. There's very specific rules. Bill mentioned this in timing for expert reports. I think the rules were changed in November 2023. There, you want to be mindful of the expert's duty to be nonpartisan. You want to be considering if any of the reports are coming in late. The opposing parties can be allowed to cross-examine your expert. You want to examine the assumptions that your experts are making and understand what the objections are and anticipate what the cross-examination is going to be. 2 or 3 assumptions in an expert report that could change the outcome of the report entirely. So you really want to get an understanding of the assumptions. You want to follow the rules. The rules are very specific in terms of what goes into the report: name, address, qualifications, experience, what the opinion evidence is being sought for, and what you're going to ask the court to rely on. The instructions provided to the expert, their reasoning, they're going to need to detail their factual assumptions, any research or tests that they conducted. They need to provide a description of the documents and information that they relied upon. They need to certify that an acknowledgement of their duty. Don't delay with respect to expert reports. You want to get them sooner than later. Oftentimes, these reports will settle the case and you can avoid a trial. Judges will order experts to hot tub if there's competing experts, and maybe they'll get it down to 1 or 2 issues, as opposed to having the testimony come out in trial and having 2 weeks of evidence where the experts simply got together. They might get the issues down to 1 or 2 days of trial time. So do that early. It allows for other investigations to be done or follow up to the expert reports, and assess the expert's skill, right? Has this person testified in the superior court before? Have they been qualified as a witness? And all these details will be provided by the expert. And if you're not sure, ask them. And there's no property in a witness. If the other person is relying on an expert, phone him or her up, ask these questions and start doing your own research and get an understanding as to the qualifications of that expert. Do you guys want to add anything to expert reports before I move on? I'm hearing crickets. Okay. The roadmap. I love this document. This goes back to the draft order. So really that draft order is my roadmap. And I'm going to map all the evidence I'm going to rely on under each order I'm seeking relief from the court for, whether it's parenting, support, property division, sale of the home, exclusive, whatever the issues are. I'm going to assemble all the evidence under those particular categories. It'll be referenced to the document brief, what volume, what tab, maybe a hyperlink to the source document. And I hand that up to the judge on day 1 of the trial. It's not evidence. I say, Your Honor, here's my roadmap. This goes with my draft order. And basically, it's just a map and a play sheet. They can tick it off as I go through the evidence. And it clearly refers the judge to the source of the evidence and where they can find it in case lines or the physical document brief that's in front of them. Judges love this. It makes their job easier. And it also helps you focus your thoughts and your submissions. And if there's a gap in the roadmap, you're going to have to understand how you're going to fill that evidentiary gap in and provide an explanation or case law if you're asking a judge to make an adverse inference or to make a finding of fact based on credibility. So that's a document that I use. Did you guys have a roadmap for the judge in your last trial?
I'm not bold enough to do that.
Well,
I think Justice Kraft would have ripped my head off.
I think the roadmap is particularly important when you're dealing with financial issues too. Like it really, ours was just on parenting. So, I think when there's so many financial documents to go through and, I think that I can see that really being helpful. Because there's so much to go through and to review in terms of documents.
It's also a good outline for when you prepare your witnesses too. They'll know how you're going to walk through the evidence and what to expect and what's coming up next.
Yeah, the outline.
Casebook, Bill Rogers, important document.
Yeah, it's not a factum, because a factum, the traditional template of a factum, has a place to write the facts. And you can't really do that at a trial because there aren't any facts. That's the point of the trial, is to find facts. So you don't have that. It's really just case law. I call it a statement of law. People call it different things. And you can tell by what you're saying in the statement of law what your point is. It's kind of, but you can't actually put facts in. And I think they used to have books of cases, but now it's all hyperlinked right into from a PDF. You can hyperlink to Canly or whatever. So that's kind of what it is. I call it a statement of law.
Yeah, great point. Do you want to add to the case book, Daniela?
No, I think Bill covered it. Yeah, the hyperlinks are important. That's really big.
Yeah, so convenient. Remember, we used to print off and photocopy cases and highlight them, and oh my God, it's night and day just within 4 years how everything has changed. Good for the environment too, right? You're producing thousands of pages and incurring thousands of dollars in photocopying costs, and now it's all just a click of a button.
Yeah.
Oh, the old days, hey, Bill. Let's talk about, we're going to break case lines down into a couple sections. First of all, filing it. And then secondly, later, we're going to talk about how we access those documents during a trial. But let's talk about filing, Danielle.
Yes, so you have to make sure you properly serve the documents, and then you upload everything with the tabs and hyperlinks onto case lines or case center, however you want to call it. You may want to discuss at the trial management conference whether the court that you're having the trial at, whether they prefer paper copies or if they do everything electronically, because 361 University does everything electronically. They don't need paper. So you don't want to spend the time printing all of that out and carrying it all down with you if you don't need it. Once you have uploaded the document to case lines, don't delete it. Make sure you have the hyperlinks to the cases or the things that you're linking to. If you're going to refer to a document, which you will during the trial, you need to know its case line's page number. That's important. It usually starts with the word master, and then there's numbers after it. If you are entering an exhibit that's uploaded in case lines, you have to know the first and the last page number, and you tell the judge, master number, blah, 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 and then it ends at this master number, and then that's when you specifically ask for it to be marked as an exhibit. So you do have to give the page number. So it's good to have those, noted, either in your handwritten notes or on your screen, so that you know quickly how to reference the document you're looking for. You may want to consult with the opposing counsel to create useful trial bundles in case lines, applicants' documents, respondents' documents, jointly submitted or consent documents, just to have it very organized and easy for the judge to see. You want to also minimize the duplicate copies of the trial bundle and try to upload your cleanest copy. And really work hard to learn case lines, or have somebody with you that knows case lines really well. And, color code your notes. You can highlight. Apparently there's all kinds of things you can do, which I learned very quickly. But yeah, either have somebody with you who's really good with case lines or learn it yourself before trial. It's very helpful.
We have a fantastic law clerk at our office. Her name's Caitlin. We call it Caitlin Lines because she knows everything about the system. It's incredible. Actually, we have a live event and a recording on how to use case lines and upload the documents that she participated in. So if you want to learn more, we spend an hour just about uploading documents. It's a great resource. Maybe Shannon, you can put that in the follow-up show notes. All right, so that's document preparation. Now let's get to witness preparation. And this is really where you can win or lose your case if you're prepared, like Bill said at the very beginning. Daniela, what do we do with the clients?
So your clients will likely be very nervous and emotional. Make sure you give your client the guidance before they're in chief in the cross-examination. You'll want to tell them things like, listen carefully to each question, listen to the whole question, and then answer the question that's asked, but answer it fully. Don't try to anticipate and answer the next question or volunteer, more evidence than just responding to the question. It's not a time for them to argue their case. So you want to make sure that they're just very, direct and concise and have simple responses. You want to let them know if they don't understand a question, it's okay to speak up and say so and to ask it to be repeated or rephrased. But they can't do that too often because then it may seem like they're trying to delay or to, using it as some kind of tactic. Tell them to tell the truth. Obviously, they're under oath. Don't anticipate or try to think ahead, and think before answering. That's a big one too. If they don't agree with a question or a statement, you want to say, like, ask them to basically ask them a further question or say no because, and then give your explanation. Never guess. And don't be afraid to admit that you don't know something. If they ask you and you don't know the answer, you don't be afraid to say that you don't know. And also there was something that's important, like make sure your clients know beforehand that during their cross-examination, they cannot speak to you during the break or in the evening until their cross-examination is complete. The judge will tell them that, but it's also good for them to know that before the trial even begins, because, if they're really particularly emotional and they feel like they need to speak to you, they're going to have to mentally prepare for the fact that they won't be able to speak or communicate with you during that period of time. So that's my feedback on preparing a client.
Back in the old days when we used to do it in person, I would tell my client, because we'd always sit together like during breaks or at lunchtimes, I'm not sitting with you this lunch. You're on your own. The optics are too bad. If you're under cross-examination,
Yeah.
I'll wave at you, but don't come talk to me. I don't want to hear it until you're done. Great tip.
Mm-hmm.
Same rules, apply for experts and third parties. If you're in person, I also, I tell my client, talk as if you're talking to somebody in the back of the courtroom. That's how far you want to project your voice. Everything's being recorded. Nods of the heads or shaking of the heads won't be transcribed, so you need to provide a verbal evidence. Like you said, Danielle, you got to be fair in your evidence. If your evidence is going to hurt your case, or you need to say it. Yeah, you just be honest with the court. If you don't, it's going to affect your credibility. Body language online and in person is super important. Judges get a lot of cues whether they think witnesses are being truthful based on their body language. Crossing your arms, pointing your finger at opposing counsel, raising your voice, going flush can be telltale signs for the court. Prepare your witness, whether it's a client or a third party, that they're going to feel this pressure on their chest and the stress come over them when they testify. The system's designed to do that, is to stress your witnesses and try to get to the truth of the matter. And so when you explain this to them, they'll understand and normalize this process and say, oh yeah, I was told I was going to feel this way. They're entitled to take a break, right? If they're not doing well, if they're crying, if they're not cognizant, I'll often ask for a break so the witness can compose him or herself. And quite, cases of domestic violence or child abuse can be quite upsetting and very difficult for witnesses to testify about. So we want to be very mindful of that when they're giving evidence. With respect to third parties, you may have to subpoena them if they're cooperating and pay the required fee, and have the subpoena issued by the court, have it served properly. Let them know where and when they need to show up for court, or if it's going to be by Zoom. there's a duty to accommodate witnesses. So what that means is you can't just willy-nilly drop a subpoena on somebody who may be out of the country. You need to accommodate their schedules and be reasonable, and the judges will direct you to do that. There's no property in a witness. When I say that is, if the other party's family has evidence that's relevant to my case, or a parent or a brother, I'll call that witness to give evidence. And it can be quite compelling, quite credible. Nobody wants to testify against a family member, but most people are going to tell the truth and explain what they observed. So that for a family member to testify against them in a trial when they're not a friendly witness to the other spouses can be really compelling evidence for the court to act on. You know, we always get the he said, she said, but for a third party without a dog in the fight who's close to the action to be brought in to give evidence, and it's being honest, oftentimes judges will rely on that evidence when determining what the facts of the case are going to be. So keep that in mind. The experts, we've talked about that briefly. You're going to want to review the reports, the CVs, the assumptions, the competing experts' evidence. You want to consider how you're going to qualify this person. There's a proper procedure to follow when qualifying an expert witness and asking a judge to accept his or her testimony as expert testimony. And you're going to want to make sure that you tick all those boxes off, and you're prepared for when the expert is going to be called. Most counsel will agree on the qualifications and will agree that the expert is qualified, especially if it's senior counsel and the experts testified in the court before. Many of these experts appear before the court, a number of superior courts, and the judges get to know and they get a reputation for being good witnesses. So even though you think you're going to object and get the evidence excluded, if the expert's known to the court, it might be prudent just to accept the qualifications and get that evidence in rather than having half a day cross-examining and qualifying the expert, only to realize that you've strengthened that expert's credibility, and now they probably got a bit of a black mark on your side of the case because the judge thinks you may have wasted half a day of court time. So that's what I would say about third parties and experts. Let's go back to our audience. It's been a while. Let's do a poll question. Next poll would be, what format of trial have you conducted or participated in? And we'll see. Did you guys want to add anything to my comments about third parties or experts? Audience members saying Thompson Router says master numbers will change and they are working on it. There's a seminar coming up in Ottawa in September, or there was one recently, so I want to keep that in mind. Here's the question, Bill. Do you need to file paper documents along with the digital ones?
We didn't. They were all on case lines, and again, you have to screen share up to the screen in court, and it's very difficult. I lost the will to live. Remember, we couldn't find the document, and I'm standing there like an idiot.
Yeah, we're getting lots of questions about the roadmap. We'll try to get a sample out for everybody in the show notes if we can. So look for that in Shannon's follow-up email. We're going to talk about business records coming up. Bill, you're getting lots of great audience feedback. My ex lied in court. What to do? That sounds like a Harry Mason scene, right?
Wait till your own client lies on the stand. That's always fun. I had a guy who he told me a million times, he was the nut bar who dug his own grave, Russ, that guy. I said, did you talk to your kid before the Section 30 assessor talked to your kid? No, I didn't say a thing. Then the Section 30 assessor's on the stand talking about how our clients, how the kid had given the expert a proposed parenting schedule that just so happened to add up to 40%.
Yeah.
Was not good.
child said, I want 40% of my time with dad. Where's a 5-year-old going to come up with a comment like that? I'm just firing through a bunch of
I
questions.
felt like
There's
strangling my client. And you know
so many
what? Every
great,
trial I've done, it's happened. The client's gone up and said, they're liars. They
there's so
all
many
are.
great questions coming in. Thank you to the audience and people watching live on YouTube for the questions. Best types of offer settle. How much do you compromise in terms of money or custody? Well, custody, you don't want to compromise too much. You're looking at the best interest of the child. Money, that's easy, right? If you make your very best offer, maybe shave 5 or 10 grand off because that's your client's going to be into it for that. They don't accept it. You got a great argument for costs. What do you guys think? What would your take on that be?
I personally have never seen a judge look at an offer to settle and say, oh, you made it on this day, so you get substantial indemnity from that day forward. That's the whole point of an offer to settle. I've never seen it done, but I'm sure it
Danielle?
hasn't done.
You
Just
have
not in
to,
front of me.
sorry, you have to do a cost benefit analysis too, like how much are you spending on trial versus how much, you don't want to throw good money after bad, as they say. So you have to, think reasonably. Can I get this at trial? Am I going to succeed with this number? And how much am I spending to get that number? And kind of go from there.
And never tell your client there's no way we can lose the way I did.
The
And then we lost.
successful party should receive some costs. If the judge is upset with the conduct of the unsuccessful party and you've got an offer that you beat, you're likely going to get full recovery costs, would be my, we got a lot of great questions. I'm mindful of the time. I just want, what factors do you consider in whether a trial should proceed with evidence in chief through affidavit or viva voce? I think I would want to go viva voce if credibility is an issue. That's the best way to make those assessments. Affidavit and an affidavit evidence, that's going to be prepared by the lawyer and approved by the client. So it's not really, you're really not going to get that same kind of flavor in terms of doing a credibility assessment. That would be my take. What do you guys think?
I've had actually the judge at the trial management conference give their opinion on whether there should be affidavit evidence in chief. So that I find that helpful because they obviously see many trials and they think, especially on the credibility issue. You're right, Russ. Like I had an arbitration when we were dealing with a joint family venture. It was all about credibility. So we had to do viva voce evidence.
If you're doing a child protection matter, affidavit can create an uneven playing field, right? So the CES has their own counsel. They can produce all the affidavits of the social workers. You've got a limited budget on your legal aid certificate and you got to prepare cross-examination based on their notes. So they're getting their case in within minutes. And now you're spending days or weeks preparing cross-examination and you don't have the funding to do it properly. So I think I'd want that evidence to go in through chief. All right, so what format of trial have you conducted? Let's see what our audience is doing. In-person hearings, 55%. So a lot of vintage lawyers with us today. Hybrid, 12%. Completely remote, 16%. That's interesting. Trial by ambush. Well, we all know a few lawyers like that, unfortunately. Uncontested trial, 12%. Uncontested hybrid, 4%. So quite the smorgasbord of audience experience. Let's go to what are we talking about next? Conducting the trial. Bill, let's get into the fun stuff. How do we conduct one of these things?
Well, as a ex-journalist and a writer, I always focus on the opening statement and keep it short. The judge wants what they call point first. The point you're trying to make, you start with that. And then the judge knows everything you say after that is supposed to support what you just said. They don't want a sense of mystery of what's he trying to say. No. Point first. And if it's okay with you, Russ, may I read very briefly from my opening statement from my trial?
Bill, I love it. I'm sure our audience would gain great insight. So Bill's going
very
to do a
brief.
dramatic reenactment of his
Yes.
most recent trial because he loves it.
This is the one I thought we'd win for sure, and we kind of did. We did well, but we didn't get what we wanted. Here it is. You ready? Your Honor. That's basically it. It's very brief. Your Honor, it is submitted that the children cannot be with the respondent father unsupervised. It is not safe. Their lives are at risk. Point first. And then I go on to talk about some
Sorry, last time
disturbing
we told this
incidents.
story, it was 20 minutes. I didn't realize. That's good because we got other things we got to cover though. Examination in chief, Daniela.
Yes, well, both of you taught me a lot about this when we were preparing for trial. We did a little trial prep at the office. You have to know the case that you have to prove. This means knowing what evidence you need to present to the court to prove your case. What evidence you need to present to oppose effectively your opponent's case, and then creating the outline of all the evidence that you need to prove. And then, you review your evidence that kind of flows from that, like you're saying with your roadmap. But the outline, it becomes your outline for trial, and you use that to prepare your client to kind of have this discussion or this storytelling with you during, giving their in-chief evidence. And your goal is to try to put your client at ease and, tell their story, and to make your client be likable and authentic in the process. So that's kind of what you guys taught me, and that's what we try to portray in our trial. That you need to really know your case, and you work backwards from there, and then you prepare your client for the talking points that you want to get across out in the during the examination in chief.
Yeah, you want to be mindful of the rules, and you're not leading your client as well.
Right.
Cross-examination, Bill.
It's basically yes or no questions usually, and there's an old rule that says never ask a question on cross that you don't know the answer to. But I find I've never done criminal law, but I think it's very different from family. You've got to follow those rules, but in family, I think it's looser. And my suggestion is don't hesitate to ask stuff you don't know the answer to. Remember when I asked the guy who had been experiencing what he called severe paranoia when he had his 7-year-old witness his last will and testament, said they might jump out the 4th floor window, and then the police broke the door down and took him to the insane asylum. So I'm asking the guy, when you had severe paranoia, did you know you were having severe paranoia? And he goes, yeah. And then I said, but isn't the definition of paranoia that you don't know it's happening? And his lawyer went, ugh.
That takes us into our next point, Bill. Objections. How do you deal
The
with
noise
it?
wasn't exactly like that. Object in a criminal trial for sure. Family law, I never object. Let it happen. I got nothing to hide. If you want to talk like an idiot and say stupid stuff, go ahead.
Yeah, I think I would disagree with that. I'd probably object if I felt the question was asked and answered. The counsel is berating my client or my client.
No, man, let it happen. It makes them look bad. But yeah, Russell, I respect what you're saying.
I think there's a point where you have to step in and say, this is not appropriate. Trial judge should do it, but if the judge isn't doing it, you would need to make that objection. Your thoughts on objections, Daniela?
Yeah, if it's something like really, really offside and outlandish, of course. I think
Well, that's different.
Yeah.
The question has to be relevant
Yes.
to an issue the court has to adjudicate, right? They don't want to hear all the salacious stuff about the affair or whatever, the court doesn't care about that. The client wants, the counsel wants to embarrass the witness, but I don't think that's relevant.
You guys are ridiculous.
Closing statements, Bill?
Closing statements, hopefully going to be more or less the same as your opening statement. And by the way, in my opening statement, I do talk about facts, very disturbing facts that I intend to prove. And there's two schools of thought on that, but it's certainly, if you can prove those facts, then go ahead and put them in your opening statement. That's the way I do it. Some people won't do it because they don't feel confident enough or whatever, but I did.
All right, so want to get some Q&A in here, and we're doing really good, but case lines part 2, accessing your documents during the trial. So we're used to having a physical copy, now it's digital. Daniela, what do we need to know? How do we do this when we're
It's
trying to
awful.
Well, you got to be prepared tech-wise. Bring extension cords or extra monitors if you can, or extra laptops, in case you have an issue with the internet. Because on our first day, we had an issue with the internet. So consider bringing like a Wi-Fi or hotspot, maybe from your cell phone or another device, because in case the Wi-Fi at the courthouse goes down, you need to have a backup. You want to continue, you want to keep this moving. You want to try to stay within, your scheduled trial time. For our trial, like there's some witnesses that maybe are out of the country or at the other side of the country, and they want to appear by Zoom, or they have some physical disabilities where they can't come into court. You have to roll with it. You have to show them, share your screen, show them the document you're referring to, have it all ready to go and organized. I think that's the biggest takeaway is if you're not strong with tech, have someone come help you that can, because you don't want to be the reason why things are being held up because you can't, access things. And case lines can be very helpful. Like it is, once you know it and once you can share and highlight, it's a really effective tool. You just have to really know the nuances.
Yeah. And the thing is too, your computer screen gets projected onto the wall of the courtroom. You should be on case lines, but if you're on, like, let's say a gambling website during the trial and it goes onto the screen, it's considered poor form.
Careful what's on your screen is what I'm hearing, Bill. All right, last poll. I want to thank the audience for playing full out. We've got great questions we're going to try to get to. Really appreciate the audience participation today. Have you ever suffered from imposter syndrome? I think this plagues the entire legal profession, but we'll give a chance for our audience to answer that. Another audience question: how important is the mood of the judge when presenting evidence during a trial? The judge seems bored with what you're presenting. How do you, this is a great question because judges will cross their arms or put their pen down. That's a cue to counsel. It's time to move on. I'm not getting anything out of this evidence. Like they're constantly giving you physical cues. That's what I'm seeing. How about you guys?
Well, Justice Kraft rolled her eyes because I kept talking about when Dad said to the kid to jump out the window. We even had a voir dire on that.
Daniela?
And she obviously didn't want to hear about it, and it's not even mentioned in the decision.
I think you're absolutely right, Russ. Like the body language is key. But I think a lot of judges also can be poker faced and really you can't really read them. And then they come out and ask a question, and then you realize what they've been thinking the whole time, and that can throw you off too. So yeah, it's definitely
Remember she typed
it's never good when you get a question you didn't anticipate.
Yeah.
If you're in person, it's a great way to manage and control the courtroom as counsel. When you're starting a case, sit there and wait. Don't do anything. The judge is plugging in her computer, getting her morning coffee ready, whatever they're doing up there. When they're ready, they'll give you the look and the nod, meaning you're good to go. So you develop these non-verbal cues with the judge, or if they need a break, they'll put up their hand, and then you stop your questioning and you wait for the court to be ready for you to proceed. So if you're seeing the pen go down, the arms get crossed, probably a good signal your case isn't going the way you think. Imposter syndrome, never 19%, always 25. Cold sweats, 36. There you go, Daniela. You're not alone. What's imposter syndrome? Okay. Quick, two things I want to cover off, and then we're going to get to imposter syndrome and final thoughts. The decision. If you're at trial, it's likely going to be reserved. You'll get a written submission, written decision later, unless you've done terrible. In your case, it's just thrown out. You're going to get the reasons. You want to get those reasons to your client right away. There's a good chance they'll be posted online at the courts on the website. If they read it from the court before they hear it from their counsel, they're going to be super upset with you. Explain the decision, consider the results, start thinking about cost issues, possibly appeals. Cost submissions, oftentimes those are in writing too, but you're going to want to have a bill of costs ready for you at trial in case the judge gives you a decision and asks for submissions on costs. They may keep it short. There may be a page limit to 2-3 pages with strict deadlines, or they may let it rip. Most judges want to keep it short. Consider the case law, consider the rules, consider whether you beat your offers. Lots to unpack there. Let's finish off with imposter syndrome. We're going to do 5 minutes of Q&A. A little bit late today, but a lot to cover off. Imposter syndrome, Daniela, did you feel this? How do you deal with it? What are your tips?
Yeah, I think that it is kind of like an outer body experience in that way, or you feel like you're acting like someone else. I think, but a lot of it is like a performance. So if you're comfortable with performing, it's part of the process. You know, but yeah, it's definitely something I struggled with.
Bill?
Well, Daniela and I, for about several months before the trial, every morning we felt like Ralphing, and that's normal. And but once you get there, it's a piece of cake.
Yeah, I'll go by quickly.
The anticipation, I think that really is that's where the anxiety, and then once it starts, you're in it, and you just do your best and you perform. That's really what it is.
You were amazing, especially when you were laughing uncontrollably for about 10 minutes, hunched over because of the opposing counsel's bizarre delivery.
Yeah. This actually plagues law students throughout law school, continues on when they become lawyers. You know, they get nightmares that they're naked, they show up without their materials, they're unprepared. Seriously, there's a theme to all these things. And cold sweats at nighttime. This fear is your body telling you to prepare, right? It's healthy. Bill started off by talking about Martha McCarthy and being prepared. Your body is physically telling you, get ready for this trial, prepare, over prepare, spend those 3-4 hours for every hour of trial time. So this is normal. It's going to happen. It's going to be okay. Call us if you have it and we'll walk you through it. But let's get some Q&A. I want to thank our audience. That was fantastic audience questions and full participation today. Really covered a lot. I know Shannon's got a few questions that she's received from the audience. And look, my God, there she is. It's like magic.
Hi, everyone. Thanks so much, Danielle and Bill, for all of your insights on this topic. And thank you so much to all of our audience. We had really strong turnout today, like Russ said. So lots of questions came in. We hope that we covered off most of them. And we're going to just do a couple more here before we sign off. So first question I have here is, when you're cross-examining, is it true you never ask a question you don't know the answer to?
That's Bill's favorite one.
Yeah, I did mention that earlier, and you're not supposed to, but I do, and I take pleasure in that. It's nothing better than having a conversation with some psycho who's on the stand.
Thanks, Bill. Next question is, as counsel, what do you do if the witness starts asking you questions?
Oh, yeah.
I never seen that
all the
happen.
time. I say, it's not your job to ask questions. It's your job to answer them. Never answer a witness question.
I've never seen that happen.
If they keep doing it, a judge will come in and direct the witness. If they're asking counsel questions, that means things are going badly and they're trying to throw you off your game. Has that been your experience, guys?
For questioning, I've had that. Like when we have questioning, I've had that happen to me a couple of times. And even sometimes the witness making an inappropriate comment. So you
Yeah.
have to kind of try to stay on your game and just say, I'm the one asking the questions here, you're answering questions.
It's a
Remember when I
control.
asked the father about the time the SWAT team came, but take him to the insane asylum, and he goes, "We don't have SWAT teams in Canada."
It's
Okay, how
it's
many
a,
policemen were there? 10, but it's not a SWAT team. Okay, buddy, thank you.
it's a control issue. You don't give control of your examination to the witness.
Thank you. And last question here, and then we'll wrap up. Are text messages evidence or hearsay?
Depends.
They're evidence as long as you have the person who wrote the text,
Yeah.
or maybe even the person who got the text might do the trick as well.
Yeah, the hearsay question is an interesting one. I think Justice Brewer taught me that in Osgood. I think there's 56 exceptions to the hearsay rule. So you don't have to know them all, but probably the most common one would be business records to get the information in. Text messages, judges love them because it tells the story, behind the scenes, what people are really saying to each other.
All right, thank you so much. I think we'll wrap up there. Thanks again for tuning in, everyone, and thanks so much again to our panelists. Russ mentioned this at the beginning, but just as a reminder, there will be a survey that pops up in your browser following the webinar once we sign off, and you can share all of your feedback there. We'd love to hear from you. And we'll also be following up with an email tomorrow, which will include show notes and links to resources that were mentioned throughout the presentation.
And if you don't want to do trial work, sign up for CP training, right?
Yes, so we'll also be sending out information in the follow-up email about the CP training, and we'll be offering our viewers a 10% discount through that. So we'll include all that information in the email tomorrow.
Well, Daniela, Bill, this has been fantastic today. Thank you so much for your valuable insight.
Thank you.
Shannon, it's been a long run. You did a great job. Thank you for being such a wonderful host today.
Yes, thank you.
Okay, audience members, have a good afternoon, and I hope you enjoyed our presentation.
Take care.